Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Welcome to another episode of Absolute Trust Talk. I'm Madison Gunn, and I'm here with Kirsten Howe, who's letting me speak today, and our illustrious guest, Lara Heisler. When we do estate plans for people, we always talk about nominating a guardian for minor children. And most people don't realize what that actually entails. And some people will hold off on doing their estate plan because they don't have anyone they want to name, or if they think that if they don't do it, then nothing bad's going to happen, right? That's generally the consensus amongst
the general
people.
superstition, right?
Yeah. So we wanted to bring in Lara today to talk about what guardianships actually look like. We just have clients sign documents saying who they want to name as guardians, but it doesn't actually contemplate what happens if that catastrophe were to actually happen. So we have Lara Heisler with us. She's been practicing law for over 25 years. Her work is primarily focused on conservatorships and guardianships. And as an experienced trial attorney, she also handles trust and elder abuse litigation. She serves as a court-appointed counsel in conservatorship cases in Contra Costa County and a court-appointed guardian ad litem in both Contra Costa and Alameda counties. She's an East Bay native and passionate about serving the community where she grew up and is raising her children. She received her BA in literature and writing from UCSD. She went to law school at USF, joined the bar in 1996 and the New York bar in 1997. That's a fun tidbit. She started as a criminal defense attorney in the Bronx. Holy cow, Lara. And then returned to California and fell in love with probate law. She's a founding partner of Heisler, Rosenfeld, and Zaragoza and assists clients with all aspects of probate and estate litigation. There's a whole other paragraph of impressive credentials that I'm not going to get into because that's not what they're here for. Everyone's here to listen to Lara, not here to listen to me rattle off her CV. So welcome, Lara. And we're very happy to listen to what you have to say about guardianships. We're excited to learn.
Thank you, Madison, and thank you, Kirsten. I'm so happy to be here because I have to say that guardianship practice is my favorite part of practicing law. And I love representing children. I love representing parents, and I love representing proposed guardians. It's really helpful work.
Great. That's good to know. It sounds as dramatic as family law, so it's good to, nice that it has that rewarding aspect to it. So estate plans where there are the clients have minor children, they usually include a nomination of guardianship, like I mentioned, to name someone to take care of their child or children in the event that both parents die, which I know is highly unlikely, but it is comprehended a lot by our clients. Can you briefly explain what guardianship consists of?
Sure. So guardianship is a custody order. Just like any other custody order, it can be changed and modified when it's in the best interest of the child to do so. I know some people think that a guardianship is either temporary or permanent, but there's no such thing as a permanent guardianship, just like how when parents are divorcing and maybe, first 5 years, the child lives primarily with mom and then has dad on the weekends, but something changes. You can always change a custody order. And there are 3 courts that do custody orders, and probate court does guardianship custody orders. Family court does custody orders when it's between a mom and dad or between 2 parents, and custody orders where neither parent is able to care for the child and the state has gotten involved. That's called dependency court, and that's where you have foster care. So guardianship's a custody order for if you as a parent are unable to care for your child. It can be because of death, it can be because of incapacity or injury, but that's what it is born of.
Okay, thank you. And I know there's 2 types of guardianship. There's guardian of their person and guardianship of the estate. Estate just means you're in charge of the child's money. We're not going to talk about that here. If you have an estate plan set up, you won't need a guardianship of the estate. So in the estate plan, the nomination might be in a will, power of attorney, or its own document, or all 3, but it's just a piece of paper. So can you explain that guardianship process? And you can use a hypothetical if that makes it easier. If someone's parents die and both those parents nominate Aunt Sarah, what does Aunt Sarah have to do?
Sure. So if you've been nominated to be a guardian, or you just feel that a guardian is needed for a child, there is a process that you can go through in all the courts in California. You can apply for an emergency temporary custody order, and you can apply for a custody order that would continue until the child turns 18, unless or until it's in the child's best interest to change it. Right. So when you're seeking custody of a child who's not yours, you're a step parent, you're an aunt, you're a neighbor, you're a grandparent, it's very paperwork heavy. It's helpful to have a lawyer or a paralegal go over the documents with you, but actually, as a practical matter, most of the time when people are seeking guardianship of a child, they do it on their own in pro per. And luckily, all the courts are aware that if somebody's coming to court to ask for custody of a child who's not theirs, we know two things right off the bat. That person probably has a heart of gold because they're willing to take in someone else's child. And B, something bad has happened in order to get us to this point. So the courts offer all kinds of volunteer assistance to help people because there's a lot of paperwork. You have to notify every person who is closely related to the child. So to make sure there's no better or more suitable candidate. So grandparents, siblings, parents, sometimes aunt and uncle, sometimes cousins, step parents, they all often will get notice. So that's how it works. It's a lot of paperwork, but it can happen really quickly, particularly in Contra Costa County, where I work a lot. If you seek a temporary conservatorship, you can go to the court in the morning. The staff will help you fill out the paperwork. You submit it, and you usually get an answer within a day or two. And then you get a temporary emergency order allowing you to have custody temporarily. And then the court would set a hearing date for you to tell the court in more detail why. In the beginning, you just say there's an emergency. Somebody needs to enroll this child in school. Somebody needs to be able to take this child to the doctor. Court, please, I know you don't know that much about the case, but just give me this emergency order and then we'll come in a few weeks when the dust is settled. And that's how it works.
Okay. And if nobody does that, let's say in the scenario that Madison described, the parents have died and this child is now an orphan, there's a possibility the child would end up in the foster care system?
Yes. So the way it works typically is if the parents are both deceased or both unavailable, and there's an urgent need to get the child placed somewhere, the Child Protective Service comes in right away. And they will try to place the child with a family member if possible. They have to do a background check and make sure they're not placing the child with Uncle Morty, the
sex offender. Yeah.
So they do a little background check and then they will place the child with a family member or in foster care. And it's pretty scary if there's not paperwork. I have a case I'm working on right now where it's awful. The mom was shot by the dad, and dad was immediately taken into custody, and mom was not available. Paternal grandparents arrived on the scene right away, and Child Protective Services was there. And after they interviewed the child, they allowed paternal grandmother to take the child home with instructions to go to court the next day and file for guardianship. So that's a pretty typical way it would work if there was like an emergency involving law enforcement. But what we see a lot in guardianship court, unfortunately, is, there's a parent with a substance abuse issue or mental illness, and grandparents or aunt or uncle or step parent or best friend's parent who comes in and says, this child is not getting the care they need, and I'm going to step in and help. That's the more typical scenario.
Oh, okay.
And you mentioned all those family members and the, who gets notice and all of that. Is there a hierarchy? Because like in probate court, right, there's a hierarchy of who can be the administrator and things like that. Is there a hierarchy in guardianship court? Like, does the aunt get hierarchy over a grandparent, or, what have you?
Yes. So no, but the hierarchy comes from the excellent estate plan that you've done with your attorney. Because if you've put a nomination in writing as a parent, the court will take that very seriously. And so if I'm the named guardian in my brother's estate plan, should God forbid something happen to him and his wife, I know this. So I would be able to immediately look for the document and bring that in along with my paperwork. And it's another piece of evidence. And that would give you a leg up over everyone else.
Okay, but that's not a guarantee. It's evidence, which the court will give they'll pay attention to it.
Exactly. And I know a lot of people, when they do their estate plan, like you said in the beginning, Madison, a real motivator is to make sure their children are taken care of when they're gone. And that makes perfect sense. And it is important to designate a surrogate caregiver. Unfortunately, there's a belief that if you do that, then presto changeo, if it happens, this is the person who's going to be in charge. And that's just simply not the case. It's one piece of evidence, and what's always going to be controlling is custody to the parents, either impossible or detrimental. And two, is the child's best interest going to be met in a guardianship? And can the guardians provide a safe and stable home? Those are the big focus of the court, which is actually a good thing, right? Because a lot of us do our estate plan maybe when we're about to have a child or when our children are 2, and we think that our own parent or our own sibling would be the perfect candidate. But then they get old and sick, or they move away, or your kid is in high school and they wouldn't want to change high schools and go live even just in a different school district. So it's great to have that piece of evidence. It's also good to always adjust your estate plan and go to your estate planner and make sure it's up to date. But it's just something to think about, that it's a vote from mom and dad from wherever they are. Rehab or the grave.
It's worth something. It's not dispositive. Would you say, Lara, that perhaps amping that up with an explanation of why you're making this choice is a good idea?
Absolutely. A couple of things I think are really helpful to give the nomination a little extra oomph is, one, if the children are old enough, have a discussion with them and tell them what the plan would be, God forbid. I've actually had that conversation with my 11 and 13-year-olds. And I was like, if anything happened, you'd go live with your Uncle Mike. And they're like, why? We'd want to live with our neighbors. I'm like, well, you wouldn't because, anyway.
That's a lot to ask of a neighbor.
It's good to have the conversation, and it's really good to put in writing why you're doing what you're doing. Like, the reason I'm selecting my sister is because I believe she's the most like me, and it will be the most comforting to my children if I'm not there. I think that she will raise them the way that I would. And then I would tell that sister, okay, I've named you. And then I would tell my mom, listen, I always would want you to be a part of my child's life, but I nominated my sister just because I'm hoping this never happens. But if it does, I want to make sure everyone's healthy and you can just be a grandma and not have to worry about raising another child. But I would have those conversations because when someone dies, everyone who's left behind who loved that person feels so helpless and so responsible. That's where we get problems, because everybody feels like a moral obligation to take in this beloved child. And then when you have maternal side versus paternal side, that's where things can get dicey.
Mm-hmm.
Do you think it would be, or is it good evidence to write the antithesis of a nomination? I absolutely do not want these 3 family members to ever have custody of my children, and here's why, or something like that. Would that be helpful, or is that
let's say I was going on a trip to Europe and I was flying with Zuckerberg in a small plane and I was nervous. Then if I had an irresponsible or abusive family member who I've kept cordial with, but I would sooner nominate Donald Trump to be their guardian or whatever, or Joe Biden, whoever you don't like, then I would maybe put something in writing about the reason, please do not put this person in charge. And I would probably give it to the person who I'd want to be in charge and have it notarized. But I mean, most people don't want to court disaster that much. You talked about people being superstitious. That's a big ask. But if you are really concerned, if there's someone in the family who you think would interfere with your plans, then absolutely put everything in writing. It's all evidence.
I assume when you hear about it, like families, they have their Uncle Morty, but he might not be registered anywhere or have a record. And so they just might want to be extra clear about that. You know, it doesn't mean it ever has to go into court. It's only if that person tried to step forward and tried to get guardianship. It doesn't have to like preemptively be spread around.
Exactly.
But I think it would be, well, like your case that you've talked about where the one spouse injured or killed the other spouse, which there's been an influx of that in the news lately, weirdly enough, for this conversation. And they immediately place the, you know, children with the grandparent. And it's like, well, doesn't common sense prevail that the parent of the one who committed the crime probably isn't ideal? I mean, it's not, doesn't mean they're bad, because that doesn't mean they, you know, by any means, but.
Funny you should mention it. That's the exact circumstance in the case that I'm working on now. And I represent the maternal grandmother who wants custody, but she doesn't live in the Bay Area. She lives further away. And paternal grandmother lived a block away from where mom, dad, and the baby were living. Mm-hmm. So she made it to the courthouse steps first. You would think that would not be that big of a deal. Turns out it's a huge deal, whoever gets there first, because one of the big things that the court cares about, and it makes sense, is maintaining stability and not sort of rocking the boat. Whoever gets there first and sets up a routine for that child and finds a therapist, gets them in daycare, or is able to replicate the kind of life they had before their loss, they're at a huge advantage. Huge.
So in that scenario, it doesn't necessarily matter who you nominated. That's just a piece of evidence in favor. But if you drag your feet for 6 months filing a petition while someone else was taking care of the child, then it's not going to have that much weight to it.
Or even 2 weeks in my case. It's brutal. And I had another case years ago where, so awful, 2 families and their young kids were on a small plane. But 2 families without their young kids were on a small plane. They were celebrating anniversaries, and the plane crashed, and it left behind 7 orphans from 2 different families. Yikes. And in both cases, they were young parents, so they hadn't really done a full estate plan, although one of the moms had written, if anything happens, I want the child to go to my mom. Well, sure enough, both sets of grandparents in both cases filed competing petitions, and the litigation went on for years because they're all grieving and everybody wants a do-over. You know, it's heartbreaking. So there's a lot of factors that go into it, but the more clear you are and the more you are able to communicate with family members what your wishes are, it will help in the end. Because, you know, like in the airplane case, the couples were so young that they hadn't really had those conversations. Yeah. And I think that if they had, it would have made the grandparents feel more comfortable with, okay, well, why are you asking and why are you asking? So,
yeah, because those competing sets of grandparents may not know much about each other.
Yeah.
Especially if the grandchildren are very young. And this is also true in other aspects of estate planning. It's the grief coupled with surprise, I think, is a very bad combination.
Yeah. Results in a lot of litigation.
I think a lot of times litigation could be avoided by having the conversation directly ahead of time so that people are not smacked upside the head with some decision they didn't see coming.
And frankly, they don't understand because they don't know what the reasoning is.
Yeah. Why did my mom leave so much more to my sister than to me?
Yeah. Or why is she leaving my money in trust? She doesn't trust me, I mean, it's a lot of just, they can't get the closure. They can't ask the questions.
They can't ask mom, why did you do that?
Exactly. I feel like in a lot of trust litigation, which we do, it seems like it's about who's going to get what, but really the nub and the core is who did mom and dad love best?
Yeah.
Right? And it can be the same way in a guardianship with deciding who the best candidate is for guardianship. Luckily, again, thank God, it's very unusual for both sets of parents to be gone because of death. And so what we see often is parents who are struggling with mental health or substance abuse issues who get better sometimes. Sometimes they do, sometimes they don't, which is why it's really important to understand that guardianship is not a permanent, unchangeable order, because it's always helpful. If you're a grandparent and you're worried about your daughter because she's in a relationship with maybe someone who's abusive and she's got substance abuse problems, and you feel like your grandchild is not safe. Well, if you go into court and talk to your daughter about it first and explain why you're going in, and this is a chance to give you some help to keep your child safe, and you can terminate this guardianship as soon as it's in the best interest of your child to do so. I don't want to take your child away forever, but you need help right now. I often wish that grandparents would have that talk with the parents first, because I find that as a lawyer, if I can get parent and grandparent together and really talk about what they want, they usually want the same thing for their child, which is for the child to have a loving relationship with everyone and to be safe. So if you can explain how you can meet those goals early on, you can avoid a lot of litigation.
Lara, do the parent whose child is now in a guardianship, does the parent still have, say, visitation rights? Is that something that the court works out in an appropriate case?
That's a really good question. And that's another distinction between when you adopt a child or when a child is placed in foster care. In a guardianship, parental rights are not terminated. So it's a custody order. So the parents, they're still financially responsible often. They're still to be consulted for medical issues and things like that. They don't have the final say, but you're supposed to keep them in the loop. And the court will create visitation schedules or create supervised schedules if that is what's in the child's best interest. The hard part is that, if a child is taken away from their parents through Child Protective Services offers visitation supervisors for free, counseling to everyone for free, drug testing for parents for free. Unfortunately, in guardianship court, it's a lot more do it yourself. So if the court has been persuaded that it's not safe for the child to be with mom or dad, it's up to mom or dad to, on their own, without an attorney, find the evidence they need to swing the pendulum into convincing the court that they're safe. So they may have to pay for their own drug tests or pay for the professional supervisor.
So it's not always like reunification first, like it is in dependency court.
Exactly, which is sad.
Yeah.
Okay. And so sort of related to that previous question, do grandparents have any kind of rights in a situation where they are not the guardian, but there is a guardian in place?
So in family court, grandparents do have visitation rights.
Right.
In guardianship courts, it's a little fuzzier. The court always wants to encourage the named guardians to facilitate healthy relationships. And when you become a guardian, you have to sign this sort of laundry list of duties of what you would do. And one of them is to maintain reasonable visitation that's in the child's best interest. So not all kids in guardianship cases get attorneys, but if they do, that attorney can be very helpful in guiding the guardian to know what kind of visitation is in the minor's best interest. If there is no attorney appointed for the kids, Because maybe at the beginning of a case, everybody agreed and the child was 6 months old and couldn't talk to an attorney anyway. Maybe, 6 years later, mom's gone through a program and grandma still feels really nervous about sending the child unsupervised. Then the court will come in and talk about what is appropriate. You were asking specifically about grandparents. The court will generally frown upon a guardian who creates unreasonable obstacles for any relative to have contact.
Okay.
That kind of led to my next question, in the sense of when you said the child was old enough or not old enough to talk to their attorney if they had one. And that is just overall, what say do kids get in this process? I mean, we all talk about it as if it's babies that are being orphaned, but in reality, they could be teenagers.
Yes.
We don't, there's a whole 18-year age range in there that, they could be. So explain how they get a say in the process. I know there's no magic number, just like family law, but how do they handle that?
Yes. So if it's very contested and there's an issue, whether the child can speak or not, the court will appoint an attorney for the child. Now, if the child can speak, it is the court-appointed attorney's job to figure out what the child wants, but they're not directed to advocate for what the child wants, which I think a lot of us who practice this law are very relieved about, because we are charged with advocating for what is in the child's best interest.
Right.
And telling the court what the child wants. Because let's say the child wants to be with mom or wants to be with an uncle who doesn't quite have it together but could. Well, then that court-appointed counsel can help make it so that it would be in the child's best interest to live with the person they want to live with. But there are statutes that say if a child tells their attorney, I want to testify, which they never do. But in my 20-year career, I've had it happen twice where the children have testified in camera, which means, just
the judge's office.
And the judge testified as to what they wanted. So as minors counsel, if the child is able to express a preference, I give that weight, but I don't give it more weight than my own good judgment. And you were talking about teenagers. It's really interesting. I have come to believe that if you have a teenager over 14 who wants to live somewhere, it's very hard to make them live where they don't want to live. It's almost impossible.
Just as a practical matter. Yeah.
As a practical matter. So it puts you in a weird place as minors counsel, because you really want to just help the family. You can be really helpful. You can help the family because you can say, your child really wants to be with you. If you do X, Y, and Z, we can convince the court. So you get very intimately involved with families when you work on guardianships as an attorney.
That's interesting. So one of the questions I get, or at least we've come across it, I don't know, probably a significant number of our estate planning cases are individuals who maybe aren't U.S. citizens, their children are, or they are U.S. citizens, but they don't have any other family here. And it might be Canada, it might be the Philippines. I mean, it can be close to really far away. What happens with that? I mean, I'm always cautious when they name people who are all overseas, and I'm like, can they take your child out of the country? Can they get here? Can they do all the things they need to do in order to get guardianship? Do you have anybody here who can temporarily, be guardian so they don't go into the, foster care system, even temporarily? No one wants that for a minute. So what are your thoughts on that? And how do you see, I know in your practice, both parents dying and the kid being an immediate orphan is rare, but that's what everyone's fear is.
It's rare, but it happens. So there is a real problem with naming someone who's overseas or who's really more than like an hour away, because kind of like I explained in my case that I'm working on now, whoever is physically there has the ability to work with the authorities to place the child in an appropriate home instead of foster care. Because the default is if Child and Family Services are called because there's a child who's alone, then the first step is to get them into a foster program. If I were an estate planner, I would, first of all, discourage my client from naming someone out of the country. But second of all, if they felt very strongly about it, then I would say if there's a teacher, if there's a friend, if there's a neighbor who you can talk to and introduce them by phone or Zoom to the person overseas, have that conversation and ask for that person to either petition to have themselves appointed as guardian or petition on behalf of the person overseas. Because if you become the guardian, the child doesn't have to instantly live with you. You can decide, until I get into the country, you're going to stay with this person. The more conversation you can have, the more writing you can have, the better. But it's really important to have a point person who is local.
Okay.
Because
What if
things happen fast?
What if the family expects to take the child out of the country? They would have to get a court order for that?
Yes, it gets complicated because,
Let's assume dual citizenship, just so we don't have to talk about any of that.
I mean, it just depends. I have cases where grandparents have been able to fly with children without the birth certificate, without the guardianship order. It just depends on who you get or like how related you look. I mean, or, really it's kind of scary, but they don't really check. I mean, we've all flown with our kids. They never really
ask.
Never.
Yeah.
So
Interesting.
there's stuff you can do.
And then is there like long-term oversight? Because I know it's just a custody order. So if no one files anything to change anything, does it just keep chugging along with no court involvement until that child's 18?
Yes.
Okay. So just like family court.
Yes.
Similar, unless a parent moves to change the visitation or custody. There's no oversight like a conservatorship.
No, but the thing that we haven't talked about that makes the court feel comfortable doing that is at the very beginning. Not only do they do like a quick background check before placing a child temporarily with a non-parent, there's also a court investigator who does a very thorough investigation, who would talk to all the relatives they could find, any therapist, any teacher. They would do a really comprehensive set of recommendations. And I think if the court had worries, the court will drag its heels on making a guardianship general. I say temporary and general versus temporary and permanent. Before granting a general, they would just keep kicking it out. I have a case right now where I represent a child and mom did all the things that she needed to do to get custody back, but I wasn't ready. So I asked, instead of terminating the guardianship, can we suspend it? There's different things you can do to provide oversight, and the court is sensitive to these issues. So they'll come up with creative ideas like, let's suspend parental right, let's do a temporary, or let's make a suspension instead of a termination.
The court has a lot of flexibility.
And the other thing is, if you're court appointed counsel, you can ask to be relieved once the general is granted, or you can serve until the child turns 18, which is what I typically do. And I tell the child, if anything happens, call me and I can go into court. There are some checks and balances.
Okay. Very interesting.
Yeah. Thank you. I think that was quite the lesson. I appreciate that, because the more we can tell our clients, the better we can prepare them for these. So it's not litigation. No one wants contested guardianship.
Yeah. If you estate planners can get as much information as possible when it looks like it could be a complicated situation for guardianship, I recommend it. And I always recommend the more family conversations, more uncomfortable family conversations you have when life is comfortable, the better off you are when life gets very uncomfortable.
Absolutely.
Always good advice. Thank you, Lara. Thank you so much. This was very, very informative for us and clearly for our audience too.
Thank you for having me.
All right. Thank you. And you can get our podcast where you're listening to it now or wherever you normally get that. Thank you. And we'll be back.
All right.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.